I'll call to order this February 12th, 2020 continuance of the Seattle Waterfront LID assessment hearing. Today's objections will be heard by the hearing examiners, case numbers CWF 89 at 9 a.m. now. We'll take a break at about 10:15. We had a case 93, or CWF 93, cancel for 1:15, and then we'll have another case 94 from 2 to 4. Let's start with case number 89. Please state your name and spell it for the record.
My name is Carolyn Hollick, C-A-R-O-L-Y-N. Hollick, H-O-L-L-A-C-K.
And do you swear or affirm the testimony you provide in today's hearing to be the truth?
I do.
Please proceed.
Good morning. As you noted, this is case CWF 89. My parcel number is 238-200-2330. I'm going to start by reading an email that I had sent in for the record regarding an objection to the waterfront lid, number 6751, resolution 31915.
So everything that's been sent in is already in your project file, so if you want to summarize, that'd be helpful.
All right. So key points here, we received our proposed final lid assessment. We object to the market value without lid amount, the market value with lid amount, and the derived amounts wherein, the special benefit amount, percent change in total assessment, as well as the process. Briefly, the history of lids are that typically the owner's residents are the ones requesting the improvements, and they have the opportunity to vote. This was not the case here. Let's see. Council member turnover, we were not properly represented in that case, as I think is noted in my email. So there were 8 council members that voted, only 2 of which we had the opportunity to vote on. The others were from different districts. The specific assessment amount for our property is inexplicably higher than the King County appraised amount. The special benefit is inflated. Our property will not, in fact, go up in value as a result of the waterfront improvements. An article from the Seattle Office of Waterfront and Civic Projects calls the waterfront a defining feature of visiting Seattle and calls it a destination park, likening it to tourist attractions. So that's part of the reason that we have no anticipated benefit from the work that's being done several blocks from us that is done to benefit tourists. I'd say those are the key points from that, so I won't belabor that. All right, so the couple things that I want to hit on today are some of the timeliness concerns, backdoor negotiations, why we have a lid, the valuation process itself, some misleading payment communications, really specific objections of our parcel. So we bought our property in 2014. It's in a condo building with just over 250 residential units and 2 commercial spaces. It's in the retail core. The area, I believe, is C, area C in the final benefits study. It's zoning doc 2500/300-550. So, as I just mentioned, we found issues upon receiving our assessment, market value without lid and the special benefit, percent change, and all the values that are derived therein. So we do, to be clear, we object to all of those. So my wife and I are residents and property owners. We are passionate about making the city of Seattle a better place. We do want that to be done in a thoughtful and legal manner. We have met with our city council representative for D7. We recognize that because of the quasi-judicial process, there's some kind of line there, but we do want to be clear as much as we can about our concerns with the waterfront lid. We have attended the previous objection hearings for the lids. We've attended meetings held by Friends of the Waterfront and various organizations so that we could educate ourselves on the planning process. I do want to be clear, we're not against the waterfront improvements. So in general, we do think that these are great efforts to support tourism dollars, and we do support it. We think the improvements do have the potential to create the great destination park that was called out by the fellow that I mentioned earlier. Our high-level concern is that the waterfront lid was improperly implemented and was rushed through right before City Council turned over. We believe that speed and greed impacted the improper calculation of the assessed value and the projected benefit. I mentioned we're also concerned about the City Council members. None of them currently are even within the assessment region. There's a clear lack of representation. At the time of the vote, Sally Bagshaw was our representative for District 7, which is the area that's impacted by the LID, and she recused herself from the vote, which left us with the 6 council members who don't represent us at all, and the 2 at large who we might have some chance of influencing. So then key 2 is different from most LIDs. We were not given the opportunity to vote on it. Any calls for public response or objection were answered repeatedly. There were a lot of letters sent in. There were a lot of people at hearings. I mean, it was actually pretty impressive how the public came out, but to date, nothing has changed. So timeliness, just at a high level, reduced ability for preparation and objection. I do understand that the court can't delay and accommodate everyone's schedules. Totally get that. I had originally intended to go to the February 4th hearing, but I was given this date instead, and so I did have to take time off work and reschedule my travel in order to attend. So kind of an inconvenience, and I was lucky enough to be able to do that. I'm not sure how many other people just frankly can't do that. I don't think I'll have the opportunity to speak with the city's appraiser today. If I understand correctly, that's going to be a little bit later, so I'll figure out that scheduling later. I'm still leaving town today, so I'll keep this as short as I can.
We do have we don't have a specific date yet, but we are putting a pin, as it were, in the schedule for the city to present on April 27th. They've indicated, at least at this point, and I'm not going to truncate their time, that they'd be on for 2 days, and whenever they finish with their case in chief, there's an opportunity for cross-examination following that of their witness. Likely a period of about 4 days, April 27, 28, 29, 30.
Is that kind of general public can attend, or is that a scheduling?
That's this room, and
okay.
This is an open public hearing.
Wonderful, thank you. Okay, good. I'm not a lawyer, if that wasn't clear already, and so it has been challenging for me to gather info on this in the short period of time without paying someone to do it, but I'm doing the best I can. So I have gone through the final benefits study and the addenda volume, which were made available on January 4th. So I've been going through that for the past month or so. I've yet not found, there was something referenced called the individual analysis sheets, and the implication was that was for the individual parcel and how those numbers were reached. So I haven't found that yet. I'll follow up on that later and keep hunting it down, but since that was referenced, I think for completion, I would like to understand more details about my parcel. Objections to the lid process. So I first looked up, what is an LID to make sure I was on the right page with this. So a local improvement district, LID, provides a way for property owners to get together to pay for street and alley paving, sanitary sewers, street lighting, or underground wiring. Property owners agree to form LIDs when the benefits from the improvements outweigh the costs. Benefits include added value to your property and improvements to your neighborhood. You pay an amount proportional to the benefits you receive for each property you own, which that makes sense to me. And the proportional part, is very clear throughout the benefit study. The local improvement districts are initiated by the property owners in the impacted area who desire improvements that they are willing to fund because those benefits outweigh the costs. So with that, I don't know a ton about the history here, but we did see from our research that in 2008, voters approved a 6-year, $73 million property tax increase for repairs and improvements to the Pike Place market. And that seemed pretty important to me as a precedent because it was voted on by those property owners and it was approved by them. So that seemed to me like a good process to go through. This seemed to me like a departure from the norm. So the process that we went through with the Waterfront LID, property owners who were being assessed for that Waterfront lid financing weren't given an opportunity to vote on the improvements themselves or the funding. And it's, again, to be clear, it's the funding mechanism that I'm really objecting to here. It's not the improvements itself. So the Waterfront lid, in my mind, amounts to taxation without representation. We didn't have control or influence over the Seattle City Council members who voted on it, and at this point, by my calculation, 50% of the council members who participated in that rush vote have turned over already. So I'm happy to have this opportunity to speak today, because I understand you'll give a recommendation to that new council, and we hope that they do recognize what to me is an illegality of action, and that they take it to vote so that we can actually get more direct input and votes from property owners. And, or cut to the chase and just find what to me would be a more appropriate funding mechanism. There was an email sent to Sally Bagshaw. I don't know who it was from, but that was posted on the documents for the ordinance itself. And Sally's response was, and I know there's no context here, but she said, "Sally here, I'm saddened by your position as a downtown Waterfront resident, current council member, your former client, and your friend. Please know we've been working on this project since 2004, and we want this lid to succeed. The decision was thoughtfully made. Not only for this project, but for the future Magnolia Bridge, we need the lids to fund major capital projects." So that to me looks like a dangerous precedent. It's literally stated in an email from a council member that they plan to use lids to start funding major capital projects, something that they haven't done before. So I think this is a kind of important case for them where they need to get this through in order to start having new ways to fund projects. Our city council has been great at finding ways to collect money. I do think they are kind of unfortunately known for not necessarily managing projects and outcomes as successfully as they could. I am not aware from my Google searching really of a broader lid based on numbers of property owners. There's over 6,000 within this LID in Seattle or in Washington State. It's also not common, from what I've read, for an LID to be proposed by government, in this case, city council. It's intended to be a tool leveraged by the property owners and administered by the government, who typically assist with financing municipal bonds and the like, from what I understand. So basically a tool leveraged by property owners, administered by the government for the people, whereas this lid is imposed on the people. So I want to now move over to some of the backdoor negotiations that took place last year. So after the initial proposal of the lid and it was going through the process, when the impacted property owners discovered that really this was moving forward, City of Seattle is moving forward with this, they are going to implement a lid without the input. The property owners did come out strong. They came down to City Hall. They signed objections to the tune of 55% of the folks that were within the region from square footage or from dollars, signed something that said, "We object to this lid entirely." However, the lid wasn't thrown out. It came very close to that number that you needed legally to throw it out, but a key organizer for that objection decided instead to work with developers to withhold a chunk of the signed objections. So they negotiated behind closed doors with Seattle city leaders, which I'm not even sure they were supposed to be talking to at that time, but I'm not sure about that. I'm not an expert in that area, to reach an agreement that only that small subset of property owners agreed to. For example, I signed an objection and I did not agree to have my objection held back. I did not want to be part of any kind of negotiations. So the total dollar figure, I think it's $160 million, that was landed on in those improper negotiations ended up being the basis for assessing those properties. So backing into the total number that they had agreed to in those closed backdoor negotiations. The goal being there that they wanted to cap the amount. The original writing, was stated so that it could extend beyond. So if the project had overrun costs, et cetera, that they would be responsible for even more than that initial assessment had said, up to 50 or 100%. I don't remember past what they were assessed at. So they saw a benefit from capping it. Okay, why a lid at all? So the waterfront improvements are actually going to be enjoyed by non-property owners, and that's great. They'll be enjoyed by a lot of folks, broader than the region and the boundaries of the lid. So we looked up some statistics on waterfront revenue. So cruises alone, as of Q2 2018, the Port of Seattle projected well over 1.1 million cruise passengers in that year, 2018, and stated that the cruise season provides over $500 million in economic value to our region. So 2018, over 1.1 million passengers with 500 million value. These numbers have been trending up since then, and the waterfront improvements will directly influence those to increase even more. So we went to the following year. There's an article from Q2 2019, again from the Port of Seattle, and this one states that the cruise business creates nearly $900 million a year in local revenue. Again, that's 2019. We don't have 2020 figures yet. I think they usually publish it in April. So the port estimated over 1.2 million revenue cruise passengers in 2019, which was well over the record number of 1.1 in 2018. Additionally, in 2019, they started hosting larger cruise vessels. So the 3 largest cruise vessels on the West Coast, each carrying over 4,000 passengers. So to recap a couple stats back to 2000, then there were just shy of 120,000 passengers in 2000, and then up in 2019, there were an estimated 1.2 million. So we've got a proven increased revenue here. That trend, we're talking 10 times as many passengers in less than 20 years. And that trend is, continuing. So it's kind of increasing as it goes along, compounded trending. So passenger increases between 2000 and 2019 is a compounded annual growth rate of 13%. So that's a huge opportunity for tourism dollars and a clear benefit there, a general benefit at the waterfront. A question, though, are the cruise passengers local? So there was a commission in 2017. The Port of Seattle commissioned the McDowell Group in 2017 to survey cruise passengers, and 89% of the respondents were out-of-state residents, so non-Washington residents. We obviously don't have information of the 11% that are remaining, how many of those were property owners within the lid. Likely not many, but that's conjecture. We don't know that. Of the 89% of those non-Washington residents, 65% spent at least 4 hours in Seattle before or after their cruise. And the bulk of that time is typically spent around the waterfront just from a location perspective. It's much easier to spend your time there if you have a limited amount of time. And the waterfront improvements, of course, are going to ensure that more of that 4 hours will be spent on the waterfront because it is going to be a more appealing place for folks to visit. So this point here is that the lid is a special benefit. So when we're going through these numbers, we're keeping in mind this is a local improvement district. This is a lid, LID. So that's a special benefit for property owners, not a benefit for visitors. So again, that does not mean that this is not a worthwhile improvement. We do think that it's a good, positive improvement. We just don't think it's one that should be funded by an LID vehicle. Okay, enough about cruise ships. Just a brief statement on Pike Place Market, which is very, very near to the lid improvements and a direct benefiter from the waterfront improvements. So Pike Place Market hosts over 10 million shoppers annually, 20,000 to 40,000 daily, but 10 million annually. It's Seattle's most popular tourist destination, and it's actually the 33rd most visited tourist attraction in the world. So this is a huge financing opportunity as well. The projections from, the Port of Seattle post-waterfront improvements alone could more than cover the amount that's currently scheduled for the LID. So there's no need to take this money from the local property owners, many of whom are not even near the waterfront. And again, it's not as much about the need so much as this is a general benefit. It's not a special benefit, but there are other ways to finance it versus desperately kind of grabbing the folks that are perceived as nearby. So financing the lid, increased revenue from cruise tourism, Pike Place Market tourism. I'm not here to solve that problem, but there are other methods to do that versus an LID, which is the improper method. So here we are, though. There is a lid. There is a proposed lid, and so I want to talk about the valuation process itself. And some of this goes back to the speed that I mentioned. It maybe comes across as not as in-depth as it could be. And given the scope of the properties, I kind of get that. We're talking about over 6,000 parcels here, so that's super difficult to do. That takes time. And so this was a very fast process. And so I do have empathy for that being a challenging thing, but I do think that perhaps it was a little too rushed, and that accounts for some of the problems with it. So the boundaries of the lid itself, they're drawn out. First of all, it's a really huge swath. It really north-south goes fairly far, but the waterfront goes north-south far. It goes east really incredibly far as well. we'll talk about the specific improvements that are proposed, but they really are around the waterfront or drawing folks to the waterfront. So it's a very, very broad region, given the spot where the improvements are taking place. It kind of looks like it's been drawn to maximize the dollars you can get from property owners, while carving out properties that could be hit up for a future LID. In addition to the Magnolia Bridge that we mentioned earlier, that Sally Bagshaw had said in an email was coming, Key Arena has been mentioned as a prospective candidate for a lid, a little bit north of us. The literal lid, the I-5 lid, literally they're talking about putting a physical lid there. That's been mentioned as a prospective candidate for LID. And so it does almost look as if some of these boundaries may have been drawn to leave space for those future things. The other part about how it was drawn, from the final special benefit study, there was a quote that said, special purpose properties, such as the sports stadiums, experience lesser special benefit due to use restrictions and location at the far south end of the project. So my wife and I actually walked this the other day and don't find this to be true. The location is at the south end of the project, yes. It is very near the waterfront, though, and it's very easy to reach. It was a nice walk. It's possibly closer than our property. So we were a little surprised that they were called out as something that would experience a lesser special benefit. There was something else in the final benefits study that I kind of summarized it as a rising tide lifts all ships kind of thing that they were saying there. The comments made on the currently strong downtown market trends are not meant to infer that the project would create further positive demand and intense development activity, but rather that the new waterfront amenities and improved waterfront access would enhance trends already in evidence in the various downtown Seattle real estate markets. So that was from the final benefit study. But my take on that is that if, as claimed, the waterfront improvements will enhance existing trends, then I'm not sure of the relevancy of even drawing those lines for the LID assessment. I mean, if they're claiming that the entire area is essentially going to be stimulated economically, then it seems as though the downtown property owners are being told to pay for something that the study itself says is there to help and follow the trends of the broader city, county, and region. There was another quote in the final benefit study that, to me, the bottom line was that it was claimed that no good comparison studies exist. So it says it's important to remember that, one, while aspects of the projects discussed and used for comparison purposes are similar, none of the projects discussed are highly similar to the Waterfront Seattle project LID, i.e. differences in view amenities, specific improvements, neighborhood and parcel characteristics, etc. And two, ongoing and proposed construction will have profound impacts on market value of individual subject properties. The magnitude of such impacts, considering the current strength of local market demand, is the major influence on property values, with waterfront projects, the subject and others, including removal of the viaduct, contributing in varying degrees. So I talked about, I think that there was a rush to get this assessment done, and I find it hard to believe that the assessor couldn't find comparable projects. There's so many projects in the world that this, to me, just seems a result of rushing it through, this inability to find a comparison study that could actually be leveraged as a baseline or for a point of comparison. So I want to talk now about valuation discrepancies. So super brief, two quotes from the final special benefits study, and this is about the proportionality that I alluded to earlier. So proportionality is an important element in any special benefit study. And then properties with similar highest and best use, similar location and physical characteristics should experience a roughly similar special benefit on an overall property basis. So I think that makes a lot of sense, but then when I look at the the final assessment roll, the valuation discrepancies within my condo building it's inconsistent. So I tried to I tried briefly to reverse engineer that methodology for valuation. There wasn't a formula or algorithm provided, so I tried to kind of back into it. But when I looked at similar properties within the condo building, I found cases where higher properties are valued lower in some cases, properties closer to the waterfront are valued lower in some cases, whereas you'd expect it to be either the same, as per the quote before, it's comparable, or perhaps if it's closer to the waterfront, perhaps it's, worth a little more, has a perceived higher benefit, et cetera. And yet I found the opposite to be true in some of the valuations. So inconsistent. So misleading payment communication, this jumped out to me that it looks to me like there's some false information being supplied based on a claim of a discount. So there's a URL, it's waterfrontseattle.org, so specifically https://waterfrontseattle.org/local-improvement-district. And so it's kind of a portal to the information about the waterfront. It's part of the Seattle Office of the Waterfront and Civic Projects. So I would consider that to be an official communication. It says, as stated in the lid formation ordinance, property owners who choose to pay their assessment in full during the 30-day prepayment period will receive a discount on the total amount of their assessment for their portion of the cost of financing that is included in their final lid assessment. So I went to the dictionary to make sure I knew what a discount was, and Merriam-Webster says a discount is a reduction made from the gross amount or value of something. And gross, in this context, as defined by Merriam-Webster, is consisting of an overall total exclusive of deductions. So therefore, a discount is a reduction made from the overall total. So the ordinance doesn't have a discount. I went back to the ordinance, number 125760. It has a couple statements that relate to this. Whereas it is the intention of this council that after confirmation of a final assessment roll and the expiration of the 30-day period for prepayment of such assessments without interest or penalty, the city will finance the unpaid portion of the assessment roll by the issuance of local improvement district bonds, LID bonds, which will provide for a deposit of bond proceeds into the city's local improvement guarantee fund in an amount to be set pursuant to the ordinance authorizing issuance of the lid bonds, but not to exceed a maximum of 10% of the amount of the lid bond issued. Those proceeds, when released from the fund in accordance with state law, will be earmarked to pay for major maintenance of the lid improvements or other identified needs related to the improvement. This council further intends that persons who pay their assessments in full during the 30-day prepayment period will not be responsible for these financing costs, i.e. the costs of issuing the LID bonds and making a guarantee fund deposit. Section 8 in that same ordinance, the 125760, says mode of payment in accordance with the provision of SMC 20.04.050. The mode of payment for the waterfront lid is payment by bonds, assessments not paid within the 30-day prepayment period provided by law shall be payable in installments of principal and interest with terms to be fixed by future ordinance. There's also some language that I don't want to read all of this because it's super long. So it's from section 12 in that same ordinance, and the language is around authorization of lid bonds and interim financing. So I read it. I'm not going to read it here. That's pretty insane. But without quoting it, my reading on that is there's no discount. It's an explanation of how someone can pay over time. So if they're unable to provide the funds in the initial 30-day payment period, which is certainly going to happen for some folks, then they do have ways that they're able to pay over time. It's not a discount, though. You're just not having to pay the interest on all these bonds to be able to finance it. So the statement that I'd read earlier, just key parts from there, this is from the website, property owners who choose to pay their assessment in full, ... will receive a discount. I think it would be more accurate to say, as stated in the lid formation ordinance, property owners who choose to pay their assessment in full during the 30-day prepayment period will pay exactly the total amount of their assessment, as opposed to owners who opt to extend the payment period and will therefore have to pay a portion of the costs of financing. So basically property owners have been issued an assessed amount. It's a total assessment that's noted on the lid roll and on the statement that each of us got as property owners. If they pay within the 30-day period, they don't get a discount. So if I pay within 30 days, I need to pay what's on that piece of paper that I received. I'm not getting 10% off or anything like that. So the reason that this matters, besides just, to me it's misleading and inaccurate, and that's bad, but it also kind of feels a little bit devious to me that owners are somehow feeling like they're getting a deal by paying the amount that they've actually been assessed at. I mean, that's just what they got to do. Or perhaps to make owners feel that it's normal to pay the interest, and that's, it's America and people pay interest a lot. So it feels a little bit wrong to me, but it also, from going back to the ordinance, to my mind, it's misstated. It's not a discount. Okay, I will move now to objections to assessment of our parcel. That's parcel number 238-200-2330. So the assessment valuation, the first thing we looked at was the King County property appraised value, because that's an easy thing to look at and we're all familiar with it, and it's online, right? We pay that. So inexplicably, the market value without LID that we received on our statement and that is on the final assessment roll is $725 higher than the King County appraised value. So that's a super weird amount because it's not even a rounding error. It's 725. So it doesn't make sense that that's a rounding error. It's just different. And so I frankly would feel more comfortable in the assessment valuation that there was some kind of logic to it if it matched, but it doesn't match. It's a super small amount higher. And so that lowers my confidence in the assessment and valuation process, which frankly I don't understand. So I mentioned earlier that there was mention of spreadsheets for individual parcels, and given the scope and the number of parcels that are contained within this full assessment, it would be super helpful to see that methodology and analysis behind our specific parcel, and it's possible that we'll get more information on that or have the opportunity in April to speak with someone about that, which would be awesome. It does seem that the burden on understanding this, what is truly a complex process, is being placed on us as the property owners. So I do think we need to be given some more information behind how those numbers were reached so that we can, kind of know the method to the madness. As it is, we're left to our own devices in figuring out if this makes sense or not. And again, for me, with that value of 725 different, I just can't imagine how he got to that, or how the assessors got to that. There is a quote also in the final benefit study that states, market value conclusions for individual parcels without the lid project, as summarized in the preceding spreadsheets, reflect the market's perception of property values in the subject area as of October 1st, 2019 date of valuation. So I mentioned earlier that we were in Area C. And that's a huge area. To me, there's insufficient description provided of the market's perception in that subject area with a degree of precision that would align to our particular parcel number. So in other words, lumping our parcel in with that broader region just does not make sense to me. Again, my parcel somehow was valued $725 higher than King County said it was. I'm not sure how that was come up with. And again, I don't think that you can take an Area C, if you look at the map, is huge, and say that everything there is going to benefit in the same way or to the same degree, or that the market perception in that area is consistent across that. So then I read something that seemed a little bit contradictory to me and almost implied that valuation actually doesn't have the precision by parcel that was claimed by the individual spreadsheets. So due to the extremely large number of parcels and unique complex nature of many ownerships, it is not the scope nor the intent of this report to address or discuss the individual valuation conclusions for each parcel. The conclusions reached are shown in the spreadsheets at the beginning of this report and briefly summarized by property classes within the subsequent valuation section. So again, that's a huge grouping, and our parcel is not indicative of an average parcel in that region or zoning. The individual analysis sheets that I mentioned, so this is a direct quote from the final benefit study, Individual analysis sheets were prepared on each affected parcel in order to form the summarized conclusions, taking into consideration all factors that affect property value and utilizing the best information available. So is it per parcel or isn't it? Because previously what was stated was that it looked at the region and then kind of top-down approach, so you look across and everybody's kind of the same. And then now it was stated, though, that the analysis sheets were prepared on each affected parcel and that formed the summarized conclusions. So I'm seeing two things in the study that say two very different things, and I am unable to tell or conclude, is it per parcel or isn't it? So without the visibility to those individual analysis sheets, we don't have visibility into the methodology for a particular parcel. So I'm just kind of unclear why there's a claim of analysis on each parcel when the study repeatedly refers to more generic methods and groupings. So I can't tell which it is. Now, I mentioned earlier that this is a general benefit, not a special benefit. And the 6 main elements in the waterfront improvements are the promenade, the overlook walk, the Pioneer Square Street improvements, the Union Street pedestrian connection, Pike Pine streetscape improvements, and Pier 58. So these 6 main elements don't provide a special benefit for our property. The proximity of the main elements, 5 of the 6, so exception of Pike Pine streetscape improvements, that they're far enough that they don't provide a special benefit for our property. And then the 6th one, the Pike Pine streetscape improvements, they are not a special benefit to us either. So they're closer, so I get that, but they would not improve our property value. There was a prior ruling on including a property that will not receive special benefits. As my property is not, it is unlawful to include any property that will not receive special benefits, and it is an unconstitutional taking of private property. So that's Heavens v. King County Rural Library District, 66 Washington 2D, 558, etc. So in conclusion, to summarize, we disagree with and object to the waterfront lid funding tactics, the last-minute decision by Seattle City Council, the dangerous precedent that is being set, and the appalling disregard for public input and opinion. We disagree with the boundaries that were drawn for the lid area. It's well beyond the immediate waterfront, but the improvements will be used by an even broader group. We object to the assessment and valuation of our property with and without the LID, and are disappointed with the lack of information on the methodology and analysis. I have just a few statements from folks who were unable to attend the hearing, but were anxious to make sure their voices were heard. And I'm gonna go through this quickly.
So this isn't concerning your case?
That's correct. Yeah, I'll provide the case numbers.
If we could provide the case numbers, there's no need to read them into it. Let's identify them by case number, and then they can be put into the case file.
Okay, great.
For that.
I have a few of them who reported that they did not receive a case number, so I did want to bring that up.
There may be people who, there are a number of people who, or I should say a small group compared to 400 of you. Many of you have understood the process quite well. There are some that simply haven't understood it. And there were some that were either there on the 4th, others that weren't. And so I understand that some people haven't quite worked through the process.
Is there a way I can help them with that? Because some of these folks, I think, would know what's up. You know, when I emailed it in, I got a case number on the subject, and it almost looks as if something broke for 2 days, and maybe the case numbers didn't come out.
Okay.
I'm guessing there, but I can let you know which ones have the case numbers and which
accounted
don't.
for it this time, and I don't have any other way of organizing them except case numbers, so those numbers are out there. If you can identify it by whatever best means you can, by case number or parcel number, if you don't have a case number, then we'll assure that the statement that we'll introduce it as an exhibit into each of those case number files.
Okay, great. I would then, if you don't mind, because I have case numbers for all but 3, I'd like to, for the ones that I don't have the case number, get those on the record.
Yeah, what you do is what I was saying is
Well, I heard what you're
the
saying.
case number.
I'm just worried about it.
I understand, but you're not here to represent them, so you can't simply just show up and start representing them.
Okay,
But I will take it into the record of what you're bringing today, and you do have a parcel number for them.
I believe
assume.
that I do. I do for some of them. I haven't checked if I had them.
If you
for
don't
all
have
of them.
any way of identifying for them, you could read it for hours,
I'll
and I
find
would
their
have
parcel.
no idea who we're talking about.
I'll
So
find
we do
their
need to
parcel.
figure it out.
I'll take care of that.
All right, let's start with the first one.
Okay. So again, though, if I've got the case number, I can skip that.
No, what I want you to, let's start with the case number one. So these are
Okay.
the easy ones. I want you to tell me the
Easy
case
first.
number. We're going to mark it as an exhibit, and then the document you're handing in will go into that case number file.
Wonderful. Okay, thank you. So the first one, the case number is CWF-0053.
And to make it even easier on you, you can skip the whole CWF, you can skip the zeros, and we just need the number.
All right, 53.
Okay.
So this is our first one.
53. We're marking this as Exhibit 1 to case number 53.
Okay, wonderful.
And you can hand that to Mr. Edlin Show.
Okay, great.
And
That's for Joyce Rogers.
Marked as an exhibit, and that will go in that case file.
Wonderful.
We have another one.
And, she had a verbal thing that she wanted me to say as well, that she is displeased about this taking money from her heirs. So she did not have that in her original letter and wanted to add that,
Okay.
if that's possible.
We'll
I
try and keep
understand.
track of that. It's
And let's see. So, case numbers. All right, this one is case number 397.
It'll be marked as Exhibit 1 for 397.
Wonderful.
And just for the record, if any of these individuals have for some reason appeared and already has exhibits being stacked into their case files, it doesn't sound like they are, but if by chance they have, and for example, they've already appeared and we have exhibits introduced for them, if the number I assigned today is inaccurate, it'll simply follow in sequence from where they've introduced.
Understood. Thank you. All right, so that's from John and LaGale, so Snowy. And
That's Exhibit 1 for that case number.
and the next case number, 27. That's 127. So this is Melody Wisdorf. She also found flaws with the property parcel valuation. And and this case number is 81. This is Jerry Meyer.
Exhibit 1 for case 81.
So he also views the waterfront improvements as a general benefit. And so now I have 3 that I do not have a case number for. I do,
Do
have
you
a.
have parcel numbers for them?
I do for this first one.
Okay, let's start
I'll
with
look
that
at each
one
as
then. All
as I
right.
hit them.
Okay, start with that one.
So Tim's parcel number is 238 200 1270.
Okay.
He submitted it via email on January 29th. And, yeah, said that.
The parcel number will be the direct route to getting that in the file. So
Wonderful,
we'll
good.
be able to
Yeah,
locate
just want to
that.
ensure he gets that. And so I do want to read that, since he doesn't have a case number. I feel nervous about this. Am I permitted to do that?
No,
Okay.
you're not here to represent other parties.
Okay.
And simply can't just allow you to show up on behalf of other parties.
Nope, I understand. They did, by the way, give me permission to do this, just so you know, but I'm not.
Understand. All right.
I'm not saying that changes the rules.
Yeah.
All right, let's see, Victoria Loico. So this parcel number is 238,
Let's let this one get marked.
sorry.
This will be exhibit number, and we're going to identify the case number later.
Great.
Okay.
Looks like I do have the parcel numbers. So this is parcel ID 238-200-2720. And this is Victoria Loico.
That'll be marked as Exhibit 1 for that case number.
She has recently bought and sold property within the LID, so I thought she had a good perspective. And only one left here. No case number, but I do have the parcel number for this as well. So this is 238-200-2070. And this is Monica Adams.
All right.
Wonderful.
These will be associated with their case numbers. And I can assure you that I do read, I have read all of the objections, so I've got to go back and read them more thoroughly. But having a statement as part of your objection is actually more effective than simply reading it into the record today. The chances of me going
That's
back
great.
and listening to every moment of this hearing are slim to none.
Gotcha, yeah.
And so
Okay.
if an objector wants to get their message through, unless it's a specific legal argument or witness testimony that's unique to their case, these types of statements are better in writing anyway.
Oh, that's good to know. Thank
Is
you.
there anything further for your case that you intend to introduce?
I do just want to introduce my own statement and, oh, sorry.
Okay.
So that's
That-
for my case.
That'll be marked as Exhibit 1 for Case 89. All of these exhibits are admitted.
And I went through today some statements. I thought it would be ridiculous to print them out, but perhaps I'm wrong. I was going to email it in because I do want to get it into the record, but would a more appropriate way be for me to print that and mail it in?
Can you clarify what you mean by statements?
Oh, sorry, the things that I went through today.
Is that not in your statement that you just introduced?
No.
So the statement, you may have been reading from notes today, and you're asking to keep the record open to submit those notes into the record for your
Well
case.
said. That is
Okay.
what I'm asking.
All
Thank
right,
you.
then the record will remain open for Case 89 to have the hearing notes introduced by the objector.
Great, thank you.
Anything further for your presentation?
No,
All right.
that concludes it. Thank you.
Anything from the city? All right, thank you very much. We will adjourn, and we will reconvene at 2 p.m. today for the next case. Thank you.
Thank you for your time.
Good
afternoon.
We are here to continue this February 12th, 2020 Seattle Waterfront LID assessment hearing. The next objection that we're hearing is case number CWF 00094.
Can you be mic'd?
I'm
Can
sorry?
you turn your mic on? Because I can barely hear you.
My mic is on. It's purely for recording purposes. So if you need some assistance with a hearing, we have hearing
So I'm
assistance
good as
programs.
long as I know what the situation is. Okay.
Could you please, as appellants, state your name and spell it for the record?
Certainly. Would you give me that case number again that you're referencing? Or
What's
was
your
that
case
simply
number?
the tax ID parcel number?
What's your case number?
My tax ID parcel number.
Oh, your case number.
It doesn't say it.
Hold on. I might have that standby. I don't have a case number. I have a King County parcel identification number, also known as a PIN, and I have our address.
As I understand it, your case number's been assigned to CWF 00094, or 94.
00094, and what were the alpha characters prior to that?
CWF.
Charlie Whiskey Foxtrot?
Yes.
Thank you.
Please state your name and spell it for the record.
My name is Stuart McGee, spelled S-T-U-A-R-T, and then McGee is M-C-G-E-H-E-E.
And are you the only one that will be testifying today?
No, sir.
Please state your name for the record and spell
Okay.
it.
I'm Dion McGee, D-I-O-N-E, McGee, M-C-G-E-H-E-E.
And do you swear or affirm the testimony you provide in today's hearing will be the truth?
I do.
Yes. I
Thank
do.
you. Please proceed with your presentation.
Thank you, Mr. Hearing Examiner. I appreciate the opportunity to present our objection to the Waterfront lid number 6751. Once again, you have us indexed with a case number. We also would like to state for the record our tax parcel ID is 2538830950. And Mr. Hearing Examiner, for today's session, I would like to address the macro of the lid assessment and then the micro as it applies specifically to our condo, which is unit 2504 in the 1521, that's 1521 Second Avenue condo building. So without any objection, I'd like to proceed. All right. First of all, do you have a copy of our objection that we filed?
Yes, I do.
Okay, great. So I won't distribute those. All right. I'd like to just hit some of the highlights of this, reading from the objection that we sent prior to the deadline. Stuart C. McGee and Dion McGee have owned this property since August of 2018. Previously, Stuart McGee and Dion McGee were renters in the 1521 Second Avenue condo building. Dion McGee, my wife to my left, is a career commercial real estate professional, having been involved in commercial real estate for 3 decades. I, Stuart McGee, am a veteran financial services industry participant. I am the founder and a principal and one of the owners of Pacific Northwest Asset Management, LLC, located at 2211 Elliott Avenue, Suite 200, Seattle 98121. So I am not only a business owner downtown, but I'm also a resident downtown. So in preparation of this objection and appeal, we discovered that the final special benefit study and addenda volume, I guess that was done by Valbridge, had not been available to property owners until January 4th, 2020, although the 237-page final study is dated November 18th, 2019, and the 214-page addenda volume is dated November 12th, 2019. So it seems to me that is a fairly short amount of time to provide a layperson like me and my wife to have the opportunity to plow through all that information and study it. Anyway, I wanted to state that for the record. I don't think you're going to give us a continuance. You already continued it from the 4th until the 12th, but it's still, in our view, a very, very short amount of time to assess and analyze all of that data. The second part of our objection is that there are, as you're probably aware, there are no plans and specifications on file with the clerk's office for the LID improvements. And it's unlawful to move to final assessment without such plans and specifications. And I cite Ordinance 125760, Section 3. It's a local and road improvement districts manual for Washington State, 6th edition, pages 3, 1931, 40, and 44, published in 2009. So once again, without plans and specifications on files with the clerk's office for the LID improvement, seems to me that it's unlawful to move forward with it, but here we sit. Thirdly, in our objection, there has been no State Environmental Policy Act review of the waterfront lid formation ordinance, and there are incomplete State Environmental Policy Act reviews of the lid improvements themselves. It is unlawful, as you probably know, to move forward with the final assessment until all State Environmental Policy Act reviews are complete for both the waterfront lid and the waterfront lid improvements. That comes straight out of the lid manual, page 3, 6, 7, 24, and 26, and SMC 25.05.800.Q, like Quebec. So, Mr. Hearing Examiner, number 4 on our objection is, without more design details and a date certain for completed construction, it is pure speculation what benefit, general or specific, if any, the lid improvements will create. And I would like to, at this point, submit Exhibit 1, which is a letter from Anthony Gibbons. This letter was written to John C. McCullough and Catherine Stanford. John McCullough is an attorney at law in McCullough Hill Leary, and Catherine Stanford is she's with CA Stanford Public Affairs. Both are Seattle companies, and I have 3 copies of Exhibit 1 that I'd like to present.
And for submitting exhibits, we just need one.
You just need one?
Yeah, we'll take one here. We'll
Oh.
mark that.
Okay.
If you brought other copies, one copy goes to the city,
Okay.
and one is simply for your own use.
And one goes where?
For you.
Oh, I've got one. Okay, thank
We
you.
have plenty.
All right, that's marked as Exhibit 1.
Okay, and would like to take a moment to read from Exhibit 1. And this letter from Mr. Gibbons, I think has an immense amount of credibility. Mr. Gibbons is with Gibbons and Raleigh PLLC, which is a real estate appraisal, counseling, and mediation firm located on Bainbridge Island. Mr. Gibbons is an MAI, which is a member of the Appraisal Institute. Those are very rigorous credentials to obtain. He's also a CRE, which is Counselors of Real Estate.
And I don't know if you were there on the 4th, but I noted that I know Mr. McGibbons at the original hearing. So
Okay.
I'm familiar with him and his work.
You are? Okay, good. All right. So are you familiar with this letter that he has written?
A copy of it's been submitted with many objections.
It has? Okay, got it.
If there are specific highlights that you want to tie into for your objection, this is a good time to do that.
Okay, yes, I would, please. And if you care to follow along, I am in on page 2 in section 1. And Mr. Gibbons, in his profession, in the appraisal profession, follows certain protocol that that is standard for the industry. In other words, the appraisal profession has a certain amount of art to it, as you might expect, simply because there is no definitive process. It's not like accounting, where there is a schedule of amortization for a certain asset that must be applied, and so the appraisal industry has certain protocols that they follow. One of the things they use, obviously, are comparables when they're appraising a piece of real estate or looking at value for eminent domain, or in this case, a lid. And he has, I think Mr. Gibbons has done a good job of enumerating those issues, and I'd like to just touch on a few of them right now. Number 1, it says lids are typically reserved for the funding of utility improvements and infrastructure within a specific neighborhood or market, and represent a means by which a group of property owners can receive and pay for improvements that might otherwise be avoided by a municipality. Perhaps the project in question has been deemed too specific or not a priority to cover with general funding. The mechanism essentially allows property owners to pay for the lid with the obvious value lift associated with, say, the provision of sewer or road. Under Revised Code of Washington 34.44.010, the cost and expense of improvements made through a lid shall be assessed upon all the property within the boundaries of the lid in accordance with the special benefits conferred thereon. The value lift associated with provisions of the infrastructure, say water or power or sewer, is typically easily measured, and specific benefits are not hard to prove and calculate. He goes on to say in the next paragraph, the current proposal to fund a regional park through this mechanism represents a special challenge for an appraiser, as the special benefit associated with an amenity, such as a publicly owned park, is not obviously beneficial in the same fashion as a utility extension, representing more of an aesthetic and a widely dependent upon factors unrelated to mere presence of the project, such as operations, public use, etc. So if, in theory, let's suppose we were to, or the city of Seattle were to decide to build a bridge from downtown to Bainbridge Island. That's an absurd thought, but if that were to be done, that would benefit the property owners on Bainbridge Island. Unlike this park, where our city officials and where all the documentation that you will see later today talks about this being a benefit for the entire city and the entire region. So I don't think we would have city officials or the mayor going to the podium and saying, okay, a bridge to Bainbridge Island is going to benefit the region. And to me, the region includes Issaquah, it includes Everett, it includes Seattle, it includes Renton, it includes the entire region. And if you want to take it even further, since the metropolitan area runs all the way down basically to Olympia, there is the possibility that when the mayor and the Friends of the Seattle Waterfront are talking about how it benefits the region, that this park will benefit the entire metro area. All those areas that I've included, down south to Olympia, up north to Everett, and possibly beyond. But I don't think a bridge to Bainbridge Island would be deemed the same benefit to somebody in Everett or to somebody in Issaquah. That would benefit the property owners of Bainbridge Island. So that type of lift in value would be far easier to measure than a public park that is in the downtown district, where the city is telling us that our property value will be lifted. Then let's talk about the special benefit. This is in section 2 on page 2 of Mr. Gibbons' letter. A successful lid is based on the correct identification of the special benefit created. Special benefits are those that add value to the remaining property as distinguished from those arising incidentally and enjoyed by the public generally. So, what I just read you, that's from the Washington Pattern Jury Instructions, Chapter 150 on eminent domain. So we have this issue of the special benefit versus the general benefit. Okay, so this lift in value is important to isolate the special benefit from the general benefit. So on the next page, continuing in section 2, in the first paragraph on page 3 of my Exhibit 1, The precise meaning of special benefit has been debated in the courts, particularly in eminent domain cases, with the same principles applying to lids. One of the clearest and often cited distinctions of special and general benefit is found in the following court decision. And I'm reading from United States versus 2,477.79 acres of land as quoted in Nichols. So this quote is, "The most satisfactory distinction between general and specific benefit is that general benefits are those which arise from the fulfillment of the public object, and special benefits are those which arise from the peculiar relation of the land in question to the public improvements. There are various common sense applications of special benefits. They cannot be remote, speculative, or imaginary. In addition, the appraiser should consider when the benefit is actually received."
Say that again. When the benefit
In
is
addition,
actually
the
received.
appraiser should consider when the benefits will actually be received. And again, this is Mr. Gibbons, who is a career appraiser making these comments. So sort of this, the Bible of valuation in litigation was written by a gentleman by the name of Jim Eaton, who was also a member of the Appraisal Institute. And I remind you, Mr. Hearing Examiner, that those credentials are rigorous and difficult to obtain. Mr. Eaton, in his book, wrote the following: "The fair market value of the remainder as the date of the valuation shall reflect the time when the damage or benefit caused by the proposed improvement or project will be actually realized." So I would also just like to point out now that this notion of when the benefit is going to be realized has yet to be determined, okay? We don't even know when the project is going to be complete. And I would like to point to a project that was just completed 1 year ago this month, and that's the State Route 99 tunnel. We all know the viaduct came down, Bertha dug the tunnel, and it just opened February 4th, I believe, of 2019. Well, that particular project, money was allocated to that project, to State Route 99 tunnel, in 2009. And the planners at that time said it would be completed in 6 years and open in 2015. Well, we know that didn't happen, okay? It opened in February of 2019, and the cost overruns were not insignificant. They were in the hundreds of millions of dollars. So, because I'm still at the macro, I just want to point out that in the appraisal profession, the actual timing of the benefit is essential to the appraisal. We don't know when the waterfront park is going to be completed. We have no idea. So,
Or started.
all right, now I'd like to move on in Mr. Gibbons' letter to Section 3 on page 2, and that's the Valbridge study. So the Valbridge study presented on behalf of the city fails to meet key test of credibility in the application of special benefit. Keep in mind that there's general and there's special benefit. And in a property lift, according to the appraisal profession, that is derived from the special benefit, not from the general benefit. At issue are the following general categories of analysis. A, special benefit definition and distinction from general benefits. The appraisal, and this is, again, referring to the Valbridge study. The appraisal makes no attempt to assess general benefit and does not offset the apparent measure of special benefit with general benefits. The appraisal ignores the basic question, and this is key. total benefit minus general benefit equals special benefit. I'd like to repeat that. Total benefit minus general benefit equals special benefit. So our lid tax is based on the special benefit, and the Valbert study seems to have omitted this key appraisal concept of taking the total minus the general to equal the specific benefit. If the evidence, and I'm reading again from Mr. Gibbons' letter, if the evidence of benefit presented by the appraiser is to be believed, it is apparent that general benefits have been included in the special benefit study. So, beyond the lack of recognition of general benefit, it is noted that the very nature of the public improvement, a regional park, and the wide lid boundary described in the report suggests the entire project could be described as offering almost entirely general benefit. Almost by definition, if 48.1 billion of real estate is impacted by the project, the benefits provided would seem very general and widespread in nature. And to elaborate on Mr. Gibbons' notion, if almost 50 billion in property is affected, then that is not narrow in scope. That is broad in scope. That is a general impact. And again, the Valbert study made no attempt to isolate the special benefit by taking the total, subtracting the general to yield the special benefit. I'd like to move on to page 3 of Mr. Gibbons' letter. This is about the middle of the page, and it would be 3D like delta. Assessments are not supported by empirical data.
Sorry, you're on page 4?
3.
I'm on page 3.
You were just on page
Sorry about that. Hold on. Let me count them. I'm sorry. I'm on page 4.
Thank you.
Thank you for the correction. So once again, 3D on page 4. And I'm sorry, the pages are not numbered. Oh, yes, they are. Top left. My bad.
I'm with you.
I apologize about that. The evidence presented for special benefit is almost entirely anecdotal. The appraisal does not provide discrete and empirical before and after analysis of purportedly similar public projects across a wide range of property takes. Anecdotal opinions of before and after without apparent adjustments for general benefits, correction of blight issues, and the passage of time do not provide a convincing case for the assignment of a 0.5 to 4% value increase to a full spectrum of property across, property types across a wide downtown area many blocks away from the improvement. I'd like to now go to the conclusion listed on page 5 of Mr. Gibbons' letter, and it says, in conclusion, the special benefit study presents several major issues. These include bullet point 1. The before condition is not adequately described. Side-by-side illustrations of the before and after are not presented. This kind of descriptive detail would appear necessary for the purposes of evaluating an amenity or aesthetic difference to be specifically created through funding. Bullet point 2, special benefits are merely assigned, not measured. We discussed that before. The study does not provide a measurement of after value with the project in place that is independent of the before value and takes into consideration delay until receipt. Purportedly measured benefits are not allocated into general and special benefits. Labeling all benefits as special does not appear credible for a regional park. And the last bullet point, benefits associated with proximity should be evaluated in the form of a lift in land value. The methodology used, open paren, a broad percentage assessment applied to total property value, close paren, results in inequitable assignments between properties. The last paragraph reads, the more general issue is the difficulty of trying to forecast a benefit that is special to a park that has regional appeal. The more common application of a lid is for the extension of infrastructure. And here, special benefits can be particularly and incrementally assessed to unserved property brought by a development condition through the provision of infrastructure. However, the application of a special benefit methodology to a downtown area for a park amenity represents a challenging and potential impossible assignment if it is to be free of speculation and imagination. So thank you for allowing me to read that, Mr. Hearing Examiner, and that concludes my review of Exhibit 1. All right. I'd like to now return to our objection and take a look at number 5, please, where it says, my property is not receiving any special benefit. It is unlawful to include any property that will not receive special benefits, and it is an unconstitutional taking of private property. And I quote, Heavens versus King County Rural Library District 66, Washington 2 Delta 58, I think that's pages 558, 564, 404, page 2D, 453, and that case was in 1965.
And if you'd like, you can skip the citations.
Pardon me?
If you'd like, you can skip the citations. I have your objection. So it's
Okay.
The best purpose of today is making your objection
Yes, sir.
in addition to what's already here, so that I can hear those arguments. And so you've, for example, in your last issue, you brought in some resolve Anthony Gibbons evidence.
Okay.
So that was helpful.
Okay.
But you don't necessarily need to read the whole thing, as it were. But if you want to highlight where you are, that's helpful to me to understand your argument.
Okay, great. Thank
But
you.
just knowing that you're not an attorney, you don't have to read the citations. It just
Thank you,
keeps it a
Mr.
little
Hearing
easier.
Examiner. Yes. Okay, just basically hitting on item 6 of our objection, the Valbridge study again. The estimated lift applied to our property is less than 4%, which is in the margin of error for any appraisal, not just the Valbridge study, and thus by definition speculation. I refer again to Mr. Gibbons' letter. Just staying organized, let me just take a second to read here. Number 8 of our objection talks about the lid is not local or intended to provide special benefits. It is regional, national, and international. So we don't see that there is any special benefit to us for that. At this time, Mr. Hearing Examiner, I would like to submit Exhibit 3. And this is a YouTube video. The URL is at the top of the screen right here. So I'll provide one to you. Thank you. And City Representative, one for you.
Right.
And so at about these,
And we're marking this as Exhibit 2.
yes,
You've
yeah,
had-
I'm sorry, it's out of
this is-
order.
This is your first one, and just for our records, you're welcome to use whatever numbers you like, but once they cross over here, we'll
Great.
put them in order.
Great.
So
Then
now
I'm
we're
gonna-
on to Exhibit.
Okay, I'll just,
Exhibit 2 for case 93, 94.
thank you very much. Because, and the reason I am bringing this to your attention, Mr. Hearing Examiner, is because at approximately the 7.5-minute mark, our mayor, Mayor Jenny Durkin, discusses how this park is for everyone. And I'd like to play just a brief clip. It's about a 9-second clip of that for the record, if I may.
I'm only pausing, I need to think just for a moment.
This is in the public domain. This is
I
not
understand
private.
that. I just want to make sure your cell phone doesn't get be part of the record, so I'm just doing this for your sake.
Okay.
I think if you play it, that'll be fine. It'll catch the recording.
Okay.
Any objection from the city?
Oh, that's fine.
All right, please
I
proceed.
don't have to take it down, right? I don't have to take this down?
No, this is considered evidence, so you don't have, it's not testimony from a present individual.
Okay, and once again, the backdrop of why I'm playing this and why I researched this is because this is a city leader who is going to the podium and declaring that this park is not local, it is regional. Okay, so here's Mayor Durkin's words.
show that this waterfront is not just for the homeowners who live here and for the people and the tourists that come. This is a waterfront for all.
Okay. Thank you, Mr. Hearing Examiner. And again, Ms. Durkin said this is not just for the residents who live here. This is a waterfront for all, so the entire region. Also, I'm not sure you're aware if, but I want to make sure I get this right. The Friends of the Waterfront, I believe that's what they call it. Let me look. I think it's called the Friends of the Waterfront, which is a partner of the City of Seattle. They have what's akin to a retail store on Western Avenue, and the cross street I think is Union. Although Union, I think, dead ends into First. If you take the stairs down to Western, there is a retail front there. That facility is open, I think, Wednesday through Sunday from noon to about 6, something like that. And I went by there, and there are diagrams of the waterfront. Again, this is a Friends of Seattle Waterfront .org retail facility, and I would like to read you one of the placards that is front and center right when anyone walks in the door to take a look. It says, "Who we are. Waterfront Seattle is a civic partnership between the City of Seattle and the entire community to create an inviting new public waterfront that is a place for everyone, a waterfront for all that the entire region can enjoy for generations." Okay? Not a peep about the downtown and how it's going to improve our property values. It talks about the entire region, and it's a waterfront for all. So this goes back to Mr. Gibbons' supposition that there is the absence of special benefit for those of us in the lid, and in particularly our unit. We don't anticipate having a lift. Indeed, we expect potentially the opposite to occur. And I'd just like to point out, as I did in my objection, that the lid improvements are great, but there is already a promenade down on the waterfront with viewpoints as well as connecting streets and bridges, okay? So we already have that infrastructure in place. So adding, several hundred million of a park, I'm not sure will add anything. As a matter of fact, I'm certain it won't add anything to our property value, as the city thinks it will.
Or says it will.
Yep. And then I would like to read number 10. The construction estimates are not based upon substantially complete construction documents, are out of date and uncertain. Final assessments will bind future city councils and budgets to complete the lead improvements regardless of the cost. It is unlawful to bind future city councils and future budgets to spend hundreds of millions of dollars on projects still early in the design process. Now, I would like to submit Exhibit 3, which is Washington Attorney General's opinion from 2012, number 4 on May 15th, 2012. And here is a exhibit, which is Exhibit 3. Sorry, I wrote 2 on the top, but I got them out of order here.
Marked as Exhibit 3.
But I believe that this was submitted as part of the original objection materials.
Part of the objection already?
Yeah.
All right.
In
We
which
don't
case
need to
we don't
enter it
need
as a
an
new exhibit
additional
then.
copy.
It's already, we've got a copy of it. I'll use it as a courtesy copy to follow
Yeah.
along with you.
Yes, sir.
but
Okay, we had a copy of the
your
Gibbons letter
objection-
as well.
Everything that you, it looks like it's all here, including the Gibbons letter.
Okay,
But,
yes, sir. Okay.
So we don't need to do copies of something you've already got.
Okay.
Some of it I can use because
Yeah, okay.
this is all stapled together. You
Yep.
want to give me something to
Okay.
read from while you're
Okay.
presenting, that's fine. Yeah.
Okay, well, I read the sort of rules of engagement
Understood.
for this, and it didn't say, it said if you're going to bring exhibits, you need to bring 4
I
copies. and
appreciate
so-
you doing that. Not
Yes, sir.
everybody's taken that effort, so
Okay.
thank you.
Thank you, Mr. Hearing Examiner. And give me one moment. Okay, well, just in the interest of time, the Attorney General's opinion speaks to this notion that it's unlawful to bind future city councils to projects where they may elect to alter that budget. But from what I understand, the minute the city takes $1 of lid money, they are obligated to complete that project. That would therefore bind future city councils to appropriate the money to complete the lid project. And according to the Attorney General's opinion, that is unlawful.
And I'm going to ask a question. I'm going to intercede here.
Actually, we can't have you interceding. I only allow one person speaking at a time.
Okay.
And so
I'll
right
come
now,
back
we're
to
hearing
that.
from Mr. McGee. I understand you'll be speaking later,
I'll come back to that.
so we'll come back to that.
Okay.
All right.
No problem.
Mr. Hearing Examiner, from time to time, yield some time to her, or do you prefer to have it?
It's better if we just do it at once. Otherwise, I'm
Okay.
trying to keep track of you. Our
Okay.
transcript is trying to keep track of the changing
Yep.
back and
No problem.
forth. Much of this goes to trying to create a clear record.
Understand,
For
okay.
appeal,
And
so-
if I were to call her as a witness, is that permissible? If she's
I think
party
we've
to the
already
complaint?
established she's going to be speaking and testifying, and as a property owner in her own right, I was allowing that, and you've both already been sworn in. So I'm just hearing from you now, and then we'll
No
hear from
problem.
Ms.
I'm
McGee.
Okay.
comfortable with that.
I'd like to repeat my question, Mr. Hearing Examiner. May I call her as a witness, as a 30-year commercial real estate veteran?
I guess I'm not following why you need to do that if she's going to testify.
I guess basically what I'm trying to do is intercept number 10. In other words, include my comment on this situation on number 10. The construction estimates are not based upon substantially complete construction documents, blah, blah, blah. That means that
So
conceivably.
let's just try to catch some order to this.
Okay.
If you need a pen and paper, I can give
I
it to
don't
you.
need a pen and paper.
And you can take
Conceivably-
notes so that when it's your turn to testify, you can do that. Right now, I've got a transcriptionist
Okay.
who's already raising
And
her
I'll go
hand
back
saying,
to
we're
number
not
two.
getting
I got a
this.
pen and paper right
So,
here. I got it.
Excuse me, you can't talk at the same time.
yeah, we really need one at a time, me, then you,
I
then
got
you.
it. Sure.
And there's no prohibition on her speaking, it's simply a matter of order
I've
when you
got
do
it.
that.
Don't worry
So
about it.
if you want to say something when your husband's speaking, just take a note of it so that
I've
when it's
got
your
it.
turn, you'll get it.
We're good.
All right,
Thank
please
you.
proceed.
Thank you, Mr. Hearing Examiner. All right, incorporated by reference, all objections made as part of the King County Superior Court case number 19-2-05733-5. That was submitted in my original. So do you need,
No, I see it here that you do, this is the third amended complaint for declaratory relief on damages?
yes.
Yes, I do have that from your original objection.
Okay,
submission.
great. Thank you, Mr. Hearing Examiner. Then I won't, as long as you understand that that's included, which clearly you do, then I'm good there. See, we join in and incorporate by reference every objection made by every other property owner. Now, if I may, Mr. Hearing Examiner, I would like to convert from the macro to the micro, and that pertains to the actual valuation of our unit, which again is Unit 2504 in the 1521 Second Avenue condominium building. It is Unit 2504, as you might surmise, is on the 25th floor of our building. The residences start on the 7th floor and go up through the 39th floor of our building. And as my wife knows as a career real estate professional, when one has a vertical property like the 1521 Second Avenue condominium building, typically the floors in the building that are higher than the lower floors, they generally draw a premium in price on the open market. Not always, but that is typically a rule of thumb that not only is applicable to our building, but to other condo buildings, not only in Seattle, but in any other metropolitan area. That rule of thumb is universal, and it's pretty well understood by consumers of these properties and real estate professionals. And in that regard, typically, if a unit is on the same floor but has more square footage, notwithstanding any views or obstruction of views, those types of things, but if it's pari passu or apples to apples, and one has more square footage, the one with more square footage typically, not always, but typically garners a premium on the open market. So with respect to with respect to the condo buildings, the condos in our building, I'm going to submit another exhibit, but before I do, I'm going to need to read some of this. We're going to talk about specific units, Mr. Hearing Examiner, but the building itself, according to the City of Seattle, is worth, after the lift-in value, $333.8 million. That is the total value. That's the sum of the total value of the let's see. I guess, what do you guys call it? The assessed value, or the value upon which the lid assessment
Appraised
is
value.
based. Yeah, I think that's it.
Appraised value.
Yeah, give me one moment if you would, please. All right, hold on here. I'm missing one document. Oh, here it is. It is the, I'm not sure what it's called because the printout, is so tiny that I had to sacrifice some columns on the right, but it's the amount of value that the city assigned to determine the special benefit of the lid improvements to the parcel. Okay? Am I in any way clear there, or is that?
I'm fully with you.
Okay, thank you very much.
Yeah.
So, for example, on our unit, the special assessment benefit of the lid, according to the city, is $65,129.4. So, and that is based, that brings our unit value, according to the city, up to $2.477 million. Okay? So when I added all of the values upon which the special benefit improvement is based, the total values, I came up with $333.8 million. And curiously, the city thinks that a building by the name of the Emerald, which is a new building at the northeast corner of 2nd Avenue and Stewart Street, is worth $183 million after the increase from the lift in value from the special benefit of the lid improvements. So the Emerald is also a condominium building, but there is no way, in my opinion or my wife's opinion, that building is worth that our building is worth 150 million more than the Emerald. So according to the City of Seattle, the 1521 Second Avenue condo building is worth 150 million more than the Emerald, which is exactly 1 block north, with virtually the same footprint. The City of Seattle has the Emerald as the gross building, the land area square footage as 16,000, and that's about the same as the 1521 Second Avenue condominium building. So if it's the same footprint, they're actually, I think, maybe 1 or 2 stories higher than us. I think they're up to 41 stories. Ours is a 39-story building. And according to the City of Seattle, our building is worth 150 million more than theirs, because the Emerald is listed as worth 183 million versus the 333.8 million of our building. I think there's no way that there's that kind of delta between that building and our building. All right, on to the specific valuations. I would like to submit this as the next exhibit.
To be marked as Exhibit 3.
Thank you. City? Mr. Hearing Examiner, as I mentioned, the type is so small that I did sacrifice some columns on the right, but this is what is published. This was a huge PDF of about 90 pages that I referenced at the outset. And I just remind you, this is, I think this is the study that was available to property owners on January 4th, 2020, that had a final date of November 18th, 2019. So when I look at these, I've just borrowed one of these sort of empty space in this center column here to write down the values of a few properties. Curiously, the city did not put the unit numbers with the various units of the 1521 Second Avenue condo building, so I had to reconcile those with an internal list that residents have access to. But I would like to point out that the Jewald, which is when you see the 1521 Second Avenue start on the list, the Jewalds it appears to be 4 residents down the page. Do you see Anthony and Donai Jewald?
Yes.
See that? Okay. So their condo, according to the City of Seattle, is worth $2.192 million. Okay? Just down the hall from them, 2 doors down the hall from them, the Jung's is worth $2.283 million. Okay? However, the square footage on the Jewal's building is incorrect. The square footage on their unit is 2,142 feet. Okay? So they have a bigger unit assessed at a lower valuation, and we talked earlier about all things being the same without view obstructions, which there are none here. Generally, the higher square footage units receive a premium, but according to the City of Seattle, the higher square footage unit of Tony and Donai Jewal is worth less than the Jung's. That makes no sense, and that speaks to, I think, the credibility of this macro study. Now, moving down that same column, if you will, I'm going to look at, see if I can reconcile this. Again, it's very difficult, so I apologize if I'm pausing, but the unit numbers are not listed on the city document, which I find curious. Let's see here. Mauer. Okay. The next one down, do you see Elizabeth Mauer? 2.3 million? Okay. That unit is on the 9th floor. That is a similar unit to ours. That is what's called an 04 stack in our building. And according to the city of Seattle, that unit is worth 2.3 million. Okay? Moving down the page to Mary Beth Austin, they are in unit 1104 on the 11th floor. So 2 floors up from Elizabeth Mauer, but the same valuation. So if we go down to the O'Briens, they're on the 12th floor. Okay, so that's 3 floors above Miss Mauer's unit. Same price, 2.3 million. All right. I couldn't find it, but on the 14th floor, Luli Yang in 1404, their unit, you guys also have listed as 2.3 million. Let's see if I can find that. Let's see. All right, let's skip down to, well, let me see here. Well, I found others. There is the Vavrick at 1604, which the city has valued at also 2.3 million. So we've gone from the 9th floor to the 16th floor with no change in valuation. I'm not suggesting that you all circle back and increase their valuation. I'm merely pointing out the fact that these discrepancies do not follow the real world. You are penalizing the individuals on the lower floor and somehow rewarding people on the higher floor because of this absence of differentiation between the certain floors of our building. There are several others all the way up to the 18th floor where the city of Seattle still is or valuing the condominium at 2.3 million. When we get to the 22nd floor, and I'm on the second page of the exhibit that I just submitted, please take a look at Denise Phillips. She is on the 22nd floor, so 2204, and that value is 2.477 million. If we go to the next one on the list, on the 23rd floor, that's the Moses, Victor and Mary Moses. That's also 2.477 million. And then the next one is the Driscoll Family Trust on the 24th floor, which is also 2.477 million. Then you get to our unit on the 25th floor, which is also 2.477 million. So we've gone from the Phillips on the 22nd floor to our floor on the 25th floor, and it's the same valuation. Same with the 26th floor for the Christ. And I'm sorry I didn't put that in there, but if you look, see 1, 2, 3, 4, 5, 6, 7th from the row from the bottom, you see Adolph and Grace that unit is also $2.477 million. So this absence of discrepancy, I think, speaks to some kind of arbitrary and capricious assignment of value by the city of Seattle that I think the Valbridge study did not take into account. In the real world, in our building, when residents are trying to market their properties, the rule of thumb is about $25,000 per floor. So if one is on the 10th floor and he or she or they wish to just go up 4 floors, that should add, in theory, about $100,000 in value to the condo. So logically, if they were to go up 10 floors, that would be a $250,000 increase in the price they would have to pay on the open market for that. So I bring this up, Mr. Hearing Examiner, to bring into question the nature of the valuations that the city assigned and the uniformity attributable to the Valbridge study makes no sense, and it is not real world. And again, I'm not suggesting that you circle back and increase the prices. I'm not sure if you could do that anyway, or the city could do that anyway, but it does speak to the validity of these values as assigned by the city. The valuation of our units, according to Valbridge, is set to increase. I would like to submit another exhibit, and let me just please make sure I have one so I can read from it. Let me see. Oh, I have plenty. Thank you very much.
Thank you.
Marked as Exhibit 4.
Thank you. And this exhibit, Mr. Hearing Examiner, that I have submitted are letters to the editor from the Seattle Times, which I think we all know what the Seattle Times is. It is a local newspaper that has been around since 1896, but this was from a few Sundays ago, Sunday, January 26th, the Sunday before the Super Bowl, if that helps. And I've included some of these letters to the editor that were on the heels of the mass shooting that occurred 1 block away from our condominium building. Again, we're between Pike and Pine on 2nd. And as you recall, the mass shooting was at Pine and 3rd, right by the McDonald's there. So this is 1 block away from our unit. And I personally wrote a letter to the editor, which is on the 3rd page of the exhibit, and it is the 3rd column from the left, entitled, "Behavior Allowed is Behavior Continued." So without going into the entire letter to the editor, the crux of this letter to the editor referred to an email that I sent to Mayor Durkin back in April, whereupon I advanced the notion that behavior allowed is behavior continued. And any of us in the city of Seattle, even today, with the police presence down there, can walk that corridor on 3rd between Pike and Pine and see drug deals going down, cash changing hands, and that behavior has been allowed by the city administration, both present and prior, multiple prior. So it's clear that the thugs have laid claim to that area. And the mass shooting was a culmination of the bad behavior of some participants in that drug and crime culture that is there. And it doesn't appear to have abated. I personally, the day after that happened, walked in business attire from
The bar.
Pike, no, one at a time, please, from Pike to Pine on the east side of 3rd, watched a drug deal go down, had a guy tell me that if I'm not careful, I'm going to get shot. So there was no police presence on that corner, and it was exactly 24 hours after the incident. This was at 5 p.m. when I was leaving a business appointment, and I could have gone just straight west on Pike to go back to our building. Instead, I thought I would walk north on 3rd up to Pine and cut across to 2nd to the condo building that way, just so I could lay eyes on what has changed. Nothing had changed. So I bring that up along with the other letters to the editor talking about crime in downtown, and particularly in this corridor, as an illustration that the city has neither the political will nor the intentions of doing anything about this criminal element. Now, I will say the police presence has increased, but I challenge anyone who's brave enough to walk that corridor to see if they can make that round trip without seeing a crime occur, okay? The thugs are still out there big time, and I think that speaks to this notion that, wow, we're going to put a city park on the waterfront, and that's going to increase our value. I vehemently disagree with that. I can't remember the name of the former city councilman after whom a park on Western and Virginia is named, but we call it the Totem Pole Park. But it's Steinbreck or... Okay, anyway, do you happen to know the park that I'm talking about?
I do.
Good, okay. That is on my walking route to work, okay? And walking back from work yesterday, there was a tent in that park, okay? That's trespassing, okay? But the city permits somebody, I presume a homeless individual, to go into that park and pitch a tent. Now, they may ask him or her or they to move along eventually, but they were homesteading that park in a pitched tent at 5 p.m. Or 5:30 p.m. when I was walking home from work. So the notion that that behavior, which is allowed, will not continue at a new waterfront park is, to me, ludicrous. I see crime continuing even after a mass shooting in downtown. I see a tent being pitched in a Seattle City Park run by the Parks and Recreation Department. And I'm not in agreement with Valbert's study that that waterfront area will not be anything more than a tourist attraction and perhaps even be a haven for homeless individuals. That is not going to increase the value of our property whatsoever. And speaking specifically to some of the improvements that are going to be a part of this lid assessment, I would like to, if I may, read from the executive summary of the Waterfront Seattle Lid Final Special Benefit Proportion Assessment Study.
As you're transitioning, Mr. McGee, I just want to let you know we will take a break at 3:15. Please
At 3:15? Okay, thank you. And again, this is from the executive summary, and I'm quoting, and this is number 5 from the executive summary. This is, it reads, Pike/Pine streetscape improvements provide enhanced pedestrian access to and from the Pike Place Market and Waterfront. Both streets between 1st and 2nd Avenues will be reconstructed as shared space without curbs. Single travel lanes westbound on Pine and eastbound on Pike, designed for slow vehicle movement and local access, will share the space with pedestrians and bicycles. Bollards and detectable warning strips help define the area to be used by vehicles, along with light poles, trees, and paving treatments, and there will be more room available for sidewalk cafes. Other improvements will be made in various blocks of Pike and Pine Streets between 2nd and 9th Avenues, planners protecting bike lanes, etc., including construction of a new paved public plaza, a flexible space designed to accommodate diverse programming similar to Westlake Park on the south side of Pine Street between 3rd and 4th Avenues. So, comments on this lid and funding of a Pike Pine streetscape improvement on the micro as it pertains to our unit. These changes to Pike Street and Pine Street between 1st and 2nd Avenue have a city estimated total cost of $20 million plus the 17% markup for the contractor and construction crews of $23.4 million. It's a lot for just 2 blocks. This change to the streets would absolutely reduce the value of our property, specifically our unit, as it would significantly restrict the existing vehicular access to and from our parking garages, which we have a lower and an upper, which is at the alley between Pike and Pine Streets and between 1st and 2nd Avenues. So our ingress and egress to the parking for our building is in this proposed $23.4 million streetscape improvement between 2nd and 1st to facilitate access to the Pike Place Market and eventually to the waterfront. Also, it would make access for deliveries to our building much more restricted. Our building had alone 15,474 packages delivered during 2019 and over 500 service vehicle calls to our building. And these service vehicle calls are electricians, they're plumbers, they're woodworkers, they're HVAC, they're elevator repair guys, they're fire system testing service contractors. So it runs the gamut of the types of service vehicles who will try to reach our building. And restricting access is going to delay their ability to reach us. It is going to delay our ability to get into and out of our building. That ingress and egress will be negatively impacted, not a little bit, a lot. So restricting our building's vehicular access will create significant gridlock in our already highly congested area by the Pike Place Market. This, in our view, diminishes, does not enhance, diminishes, devalues our property, does not enhance it at all. It's 3:10. Can we go early, Mr. Hearing Examiner, on the break?
Tell me more about your presentation. How much longer do you have to go for your presentation, and then we're going to hear from Ms. McGee.
We're going to discuss that during the break, and I would also very much appreciate a bio break if we can adjourn early. If not, I'll go to the gentleman's room.
Do you have any sense of time now that you can tell me?
I'm going to simply say that he's been so comprehensive, I'm impressed, and that mine will be very minimal.
Okay, that's
okay.
helpful.
Well,
you don't have to curtail
it'll be
yourself
very
now,
minimal
but
because
am I
he's pretty much
understanding that
covered
you're
most
nearing
of
the end of it?
Yeah,
points.
we are nearing the end of it. I would like to huddle up with her.
We will take a short break. Why don't we come back at 3:25?
Yeah, I mean, I'm going to have very little to
That-
say after
that's
he's,
We'll
great.
see you at 3:25.
Thank you, Mr. Hearing Examiner.
he's done his magic. Okay. I'm Deanna
And
McGee.
are you going to proceed?
I'm
Okay,
gonna
are you finished,
proceed.
Mr. McGee? Did I
I
understand?
would like to make a conclusion after her remarks.
All
if
right,
that's
we'll
acceptable
save
to
you the opportunity for closing for you, and then we'll proceed.
Yeah, I'm going to have only 2 items that I'm going to present.
All
It's
right.
going to be very simple.
All right.
Okay, number
Please
one,
proceed.
because
I
he's
can
so,
barely hear her, just so you know.
Okay, because he is so comprehensive and he is so thorough, then I only have to ask one question. He confirms, or he ensures me that there will not be an additional lid tax if y'all have cost overruns, et cetera. Okay, in other words, that this is a one and only time lid tax on our condominium, which is important for resale value, okay, extremely important, that we would not have another lid tax that we would have to play into a sale, okay? That's number one. Do you have your assurance that this would be the only lid tax on unit number 2504 in 1521? Oh, I can't ask a question?
No, I'm not here to assure you of anything. I'm here to hear your evidence and their evidence and make a
Okay.
decision.
Okay.
And make a recommendation based on
Okay,
that decision.
So that was one question I had, but we won't ask a question. Now, the next thing I'm going to mention is the fact that this gentleman came up with an arbitrary number of $65,000 worth of benefit to our particular condominium. This woman, this person, I don't know who it was, okay, but this appraiser came up with an arbitrary number of $65,000. All right, after, like he told you, I've been in the real estate business for 30 years, all right, Valbridge. Any kind of a tax diminishes the value of a piece of property, okay, no matter what. Basically, you have to factor it into a sale or a purchase, okay? Period, end of story. And this person, Valbridge, this company, doesn't quite understand that the value of a condominium or house or even a retail shopping center or what have you is worth only what the market will bear, okay? It is completely market generated. So, in other words, 2008, the market collapses, okay? You have to factor that in. So he can't tell me or my husband that $65,000 is what we're going to benefit when he's not factoring in market conditions, okay? There is no crystal ball here, okay? Basically, there's no crystal ball. And the time value of money, obviously he understands all of that, et cetera. I'm gonna conclude with that because of a note he's sending me, which is to be brief. So I'm going to be brief and let him close. How about that?
All right, thank you.
So, I mean, I concede to him.
All right, then.
Thank you, Mr. Hearing Examiner. And I would like to just sum up some points that we hit today, just to make sure that they are emphasized for the record and otherwise. But the absence of specificity with respect to the timeline of the project is one of the key components to our objection of the lift value of $65,000 on our property. As Mr. Gibbons noted in his letter, when the benefits are enjoyed by the landowner are critical to any type of appraisal. So the absence of specificity of a timeline is a critical component to our objection. Because there are no plans and specifications on file in the clerk's office of the lid improvements, it again is unlawful to move forward to final assessment without such plans and specifications being in place. Just a reminder about the tunnel project, and I know of, there may be some, but I know of no large-scale public projects that have been done in Seattle on time and on budget.
Even Key Arena. Okay.
So perhaps I'm jaded, but I do not have faith that the waterfront project will occur on time or on budget. We will see if it moves forward. But I'd also like to remind the city that once $1 of lid tax is accepted, the city is bound and obligated to complete that project. So that binds future city councils and their budgets to allocate proceeds to complete that project. And according to the 2012 opinion of the Washington Attorney General, that is unlawful. So we object to the waterfront lid assessment of $65,129.40 for Unit 2504 in the 1621 Second Avenue condominium building. 1521, I apologize. And we respectfully submit that our objection be heard by the city and action taken to eliminate or reduce that. Mr. Hearing Examiner, I appreciate your time, your courtesy, and the time and courtesy of everyone involved in hearing our objection. Thank you very much, sir.
Thank you for the same. All exhibits are admitted. Is there anything else further that you intend to submit?
No, sir, not at the present
Anyone
time.
sitting?
Yes, thank you. I just have one follow-up point to make. I believe in your closing statement, you said that your proposed assessment was $65,000.
Excuse me, that was the value lift special benefit. Sorry,
Okay.
yes, ma'am.
Yeah.
Our assessment is $25,519.13 derived from the special benefit of $65,129.40. So thank you.
You're welcome. I just wanted to clear the record for that. And then I have some follow-up questions for you.
Ma'am.
On your, what's been marked as Exhibit 3, this spreadsheet,
Right. That's not my spreadsheet.
or,
That's, yeah,
sorry, yes, the spreadsheet from Valbridge.
right.
You've indicated here that the square footage on one of these units is incorrect and should
Yep.
be 2.142 square feet?
No,
or
no, 2,142.
2,142.
Yes.
Where did you derive that figure from?
Just the front desk of the building, of our building, gave me that number.
Okay.
Yeah, the
Thank you.
concierge at our building.
Okay.
Yeah.
And in looking,
And I actually know Tony and Donai Jawald quite well, and their unit is huge. So when I saw the 1,642 feet, I knew that wasn't right.
okay,
Okay.
thank you.
Yes, ma'am.
Did you identify any discrepancies in the square footage of your own unit?
May I add something?
You'll have a chance in a bit. And she has an opportunity to cross, and then we'll come back.
Okay, I just wanted to add something. when it was
One
brought
at
up.
one at a time, honey.
Okay.
I did, but it's only 1 square feet difference than what is on our closing statement from our purchase in August of 2018.
And is that 1 square foot too many or too few?
Too few.
Too few. Okay.
Yep.
And in the column of this property address column, you've indicated in handwriting the value in millions. Is that the value with the lid?
Yes, with the special benefit. Yes, ma'am.
Okay. And were these values somewhere on this original spreadsheet?
To the right.
To the right. Okay. I
Yes.
just want to make sure that.
Yes, but I don't know if you've seen that PDF, but it is huge, and even on a full screen in my office, and I have a very large screen, it is still very difficult to read. So when I printed it, I elected not to crunch it down to fit the screen because none of this would be legible.
I appreciate that. I just
Yeah.
wanted to confirm for the record that these figures are reflected on the full spreadsheet.
They are indeed to the dollar, and I round it, of course.
Sure.
Yes.
Thank you. And you are not a certified real estate appraiser, are you?
No, ma'am, I am not.
That's all my questions for Mr. McGee.
All right. You've essentially been your own witness. You gave your presentation. There was cross-examination. Now you have a chance for a redirect. Do you have any additional comments following the questions from the city? And
Yes, sir, Mr. Hearing Examiner, I do have one comment. I am not I think your question was a certified appraiser? Okay, no, I am not a certified appraiser. I have, as I mentioned at the outset of this objection in this hearing, that I am a financial services industry veteran. I have been in the business for over 2.5 decades, and in our particular firm, Pacific Northwest Asset Management, every one of our clients in their investment portfolios have exposure to real estate through the form of real estate investment trust, also known as REITs. And REITs are a unique, publicly traded pool of commercial cash flowing assets, and it is our fiduciary responsibility to all of our clients to do due diligence on any of these real estate investment trusts that we place in their portfolio. And in the course of that, I feel like I've gained a tremendous amount of knowledge and expertise in assessing the value of real estate in these real estate investment trusts. And then in addition to that, I personally own a good deal of real estate. It hasn't ever been affected by a tax from a lid, but real estate is not foreign to me. It is very familiar to me, so I'm not a complete fish out of water when I'm addressing these issues, just for the record.
thank you. Ms. McGee, did you indicate you had something else to add?
No, I'll
All right, then.
let it go.
Thank you. We're adjourned for the day. Thank you.
Thank you, Mr. Hearing Examiner. Thank you, everyone.